the agency messes up and we want to sue them. One thing you mentioned is if something's with these delays, if it's reasonable or not. What is reasonable delay? If something is in administrative processing at the embassy stage and 6 months, 1 year, when you pull the trigger on the lawsuit?
Congress has said that 180 days is what they consider to be a reasonable amount of time for immigration benefits. That's in the I believe it's the AC 21 law from 2000, American Competitiveness in the 21st Century Act. USCIS is going to argue that the advertised or the reported processing times on their website are reasonable. And I think, unfortunately, some lawyers kind of agree with that and say, well, if it says 48 months on the website for an EB-5, I'm not going to bring a lawsuit earlier than that. So if the time frame that the government has already engaged in, if it's already been more than 180 days, you may be able to bring in the lawsuit right away at that point. If you look online and see, well, Congress said 180 days, USCIS is taking 3 years, then I think you need to look at the case and decide, is it reasonable for CIS to take this long? And if it's a 601, if you're talking about, or a nunc-pro-tunc case, something very complicated, discretionary, probably don't want to bring a lawsuit on that, or you might want to consider other options first. But if it's a standard case, like an EAD application, I-765s, all they're looking at is, does this person qualify based on the code number that they're listing on the 765 application? If it says C26, and that means that an H-4 worker can get an EAD card, there's no interview for that. That should not take 8 months. So for those lawsuits, if it says 6 months online, I say bull crap. Let's file a lawsuit and make them prove that this is reasonable. And if you're going to bring a lawsuit earlier than what's kind of standard, earlier than 6 months, you need to advise USCIS that there's a problem in the case, that the person needs expedited processing. And then when they deny the expedite, then you go to the government, to the lawsuit, and say, hey, we asked for 2 expedites. We gave them medical records. We showed them what's wrong here. We went and tried to get a 551 stamp. Whatever you can do to exhaust those remedies, that's going to make your lawsuit seem a lot better versus everyone else just saying, hey, I want to file my lawsuit now because the government's taking too long. Cookie cutter lawsuits don't impress the government. Lawsuits that show and tell a story and show why your client has a problem, why the delay is unreasonable, that's the kind of lawsuit where you might win through negotiation where you would have lost ultimately in court.
Mm-hmm. I hope you enjoyed this short clip from the material of the Immigration Lawyers Toolbox. If you want to get more information about becoming a premium member, just email me at info@immigrationlawyerstoolbox.com or visit the site immigrationlawyerstoolbox.com, where you'll see links to a lot of the information that we have for premium members so you can get a better idea of what's there, as well as on the YouTube page for the Immigration Lawyers Toolbox, where we have much more clips and material that's helpful. If you wanted to buy something a la carte, visit ilt.thinkific.com.